has begun voting on several versions of how the U.S. should define civil rights on the job. The Democrats' plan would make it easier, or less difficult, for minorities to win job discrimination suits. The Republicans claim that would force companies to set aside a certain number of jobs for minorities and women. In a word, quotas. Here's ABC's Cokie Roberts.
The civil rights debate that's been raging outside the Capitol came inside today, where Republicans repeated the now familiar charge, it's a quota bill.
Even worse than just a quota bill, if you hire by quota in this bill, you face a lawsuit. If you don't hire by quota, you still face a lawsuit.
Democrats have been unable to tear off the quota label despite specific language in their bill deeming the use of quotas an unlawful employment practice.
Mr. President, read the bill before you hit the road. This is not a quota bill. It specifically outlaws quotas.
Calling this not a quota bill reminds me of an old Italian saying, though you dress the shepherd in silk, he still smells of the goat.
Republicans claim that other language in the bill will prompt employers to hire set numbers of minorities and women rather than risk discrimination lawsuits. Democrats counter that this debate has nothing to do with language and everything to do with running for office next year.
Even if this bill were the Quota Abolition Act, the White House would still say it's a quota bill.
No one can say with absolute certainty whether this civil rights bill would encourage quotas if it became law, but for it to become law, Congress would have to override a threatened presidential veto. So far, Democrats have been unable to attract the two-thirds vote necessary for an override because members fear the quota label, valid or not. Cokie Roberts, ABC News, Capitol Hill.
While Congress fights about the political effects of the Civil Rights Bill, businesses and individual workers, not to mention lawyers, are trying to figure out what its practical effects would be. One effect would be to put the burden of proof back on employers to show that their hiring practices are not discriminatory. Here's ABC's Bob Jamieson.
2 decades ago, a lawsuit forced a hiring quota on Alabama's entire state police force to end discrimination against blacks. But lawyers say this case is rare. The vast majority of civil rights cases do not lead to quotas. Doug Huron was a lawyer in the Alabama case.
I think your typical employment discrimination suit today, all over the country, involves one individual who feels that he's been discriminated against, plain old-fashioned garden variety discrimination.
They are individual cases like that of Richard Glenn, a postman in Florida for 22 years. Glenn claims he was denied a coveted rural carrier's job because preference was given to whites. But his lawyer dropped plans for a lawsuit in 1989 when the Supreme Court's rulings made it extremely hard to win suits for job discrimination. The lawyer, Kent Spriggs, thinks he would be able to win under the bill opposed by the administration.
It basically would just set the law back to where it was for 20 years. Everybody knows that for 20 years we did not have quotas when the courts were analyzing these kinds of claims.
But the owner of this eyeglass business in Atlanta believes the Democrats' bill would not make things right, but wrong again. The company already has an integrated workforce of 1,300. But the bill, he argues, would force his business to defend itself against any complaint by any disgruntled employee charging discrimination.
We do what's right now at our company. We plan to continue to do that. But we fear that this type of legislation, loosely drawn and poorly defined, will end us up with more charges and more legal expenses, which we cannot afford.
In these cases and others, a new civil rights bill is provoking hope or anger. The debate is about politics and about reality. Bob Jamieson, ABC News, New York.